Orders of the day. Senator Lyons is not here. Senator from Chittenden.
I would move that we pass over H 482 and move to S 87.
S87 was passed by the House with a proposal of amendment. The question is, shall the Senate concur in the House proposal of amendment? Senator from Windham.
Thank you, Mr. President. Senate Judiciary has voted to concur with the other body's amendment to S87. The original purpose of this bill was to update our existing extradition laws. Extradition is a process that's required under the U.S. Constitution and involves surrendering the custody of a fugitive from one state or country to another state or country. The only change that the other body made involved the waiver of extradition proceedings. Their proposal adds a layer of judicial review to ensure that the defendant confirms they previously waived their rights. A previously signed and authenticated waiver will be presumed valid. However, the defendant will have the opportunity to contest its validity. This is also on top of the other opportunities that a defendant has to petition the court. That includes the writ of habeas corpus or having a weight of the evidence hearing. The person is held without bail. If the defendant doesn't meet the burden to prove that the waiver is invalid, the court can proceed as if the person has consented to return to the demanding state. We heard from the state's attorneys and sheriff's office, the governor's general counsel, the attorney general, the defender general, and legislative council. The vote was 3-1-1, and we ask for the Senate's support.
The question is, shall the Senate concur in the House proposal of amendment? Are you ready for the question? If so, all in favor say aye. Aye. All opposed, nay. Nay. The ayes appear to have it. The ayes do have it, and we have concurred in the House proposal of amendment on S87. We will now go back to the top of the action calendar. We have on the calendar for action H482, which was passed by the House on March 18th of 2025. It was referred to the Committee on Health and Welfare, which reports it has considered the bill and recommends that the Senate propose to the House that the bill be amended as it appears starting on page 1666 of today's calendar, and that with such proposal of amendment, the bill ought to pass. Listen to the second reading of the bill.
H482, an act relating to Green Mountain Care Board authority to adjust a hospital's reimbursement rates and to appoint a hospital observer.
I recognize the senator from Chittenden Southeast District, Senator Lyons, for the report of the Committee on Health and Welfare.
Thank you, Mr. President. 482 is an emergency response bill. We are looking at very carefully at what's happened to our only domestic health insurance company in the state, Blue Cross and Blue Shield, and they're very close to insolvency. Blue Cross and Blue Shield requires about $35 million a week to pay claims, and at last count, they were getting very close to having $50 million to pay the claims week after week after week. So the reserve funds were low, and their solvency level was reaching the level of insolvency. So the first part of this bill deals with how to save our domestic insurer when they approach insolvency. The second part of the bill that we will look at is the result of some material misinformation that was supplied to the Green Mountain Care Board. And when material misinformation is supplied to the Green Mountain Care Board about a hospital budget, what can happen to rectify that situation? So the bill is very much a bill of extraordinary measures. It isn't a bill that takes place every day or every year. In fact, the provisions of the bill are emergency response to the healthcare crisis that we face. Earlier this session, we passed S-126, which is a longer-term response to reducing healthcare costs. This bill allows for some balancing out of reimbursement to hospitals and to assuring that insurance companies are maintained, our one domestic insurer is maintained in the state so that the thousands of Vermonters who have healthcare premiums with Blue Cross and Blue Shield are protected, and that those premium costs don't escalate when there are increased costs that may not be defensible. Let me just give you an example of why we're looking at parts of the bill. If you look at insurance companies build contracts with hospitals and providers, but those contracts are black boxes, so we don't know really what's in them. And then what happens is that hospitals decide how much money will be paid for each service that they offer. So each code, for example, for those of you familiar with coding. And one example is that one hospital put in place a code reimbursement rate of 528% of Medicare. That's extremely high. As you know, when we talked about S-126, we said that a price of a reimbursement rate of 250% or 300% would be a good amount. But we have found out, the Green Mountain Care Board actually has found out that one hospital put in place a reimbursement rate of 528%, and they did it for those services that are utilized at a high level. Well, what does that mean? That means that the reimbursement that comes from Blue Cross and Blue Shield for those commercial payers, that reimbursement is high. And the result is that the budget goes sky high for that hospital. So that's one case, that's one place where we see a problem. So that's part two of the bill, actually, Mr. President, but I think it's very telling that when we have that type of uneven reimbursement, a hospital could demonstrate increased utilization and get paid for that high utilization at a cost that we can't bear. So I'm going to go right to the bill, Mr. President, and go through it with you, and then we can have questions afterwards. So Section 1 of the bill is a reduction or allocation of reimbursement rates. So this is a section of the bill that deals with the health insurer solvency. So if a domestic health insurer faces an acute, immediate threat of insolvency because of its very low reserves, and as I've said with you right now, Blue Cross and Blue Shield has very low reserves, and they are approaching insolvency. In fact, they've actually taken out a loan with their parent company so that they can maintain solvency. But anyway, this section allows for the Green Mountain Care Board, after consulting with the Commissioner of the Department of Financial Regulation, to reduce the health insurer's reimbursement rates to one or more hospitals. So if there's a hospital that seems to be out of line, perhaps with their reimbursement, the Green Mountain Care Board can look to those hospitals to help solve solvency, help the insurance company. And I just want to pause here for a minute and say, the Green Mountain Care Board would like us all to know that they will not be attacking every hospital in the state. There are hospitals that can tolerate this level of scrutiny and this level of reimbursement change. There are other hospitals that we know are fragile or are becoming less fragile, and financially, we want to maintain financial sustainability for hospitals. So not all hospitals are targeted here. Vermont only has one domestic health insurer, that's Blue Cross and Blue Shield. And so the Green Mountain Care Board could reduce rates to a hospital that meet one or more of the following criteria. So there are specific criteria that would allow for rate reduction, reimbursement reduction. That the hospital must have 135 days cash on hand and a positive operating margin in the previous fiscal year, or the hospital, if it's a member of a hospital network, that the network has more than 135 days cash on hand or had a positive operating margin in the previous fiscal year or both. So Green Mountain Care Board can only reduce reimbursement rates to the extent necessary to remediate the threat to the health insurer's solvency and must consider competing financial obligations of the hospital and of the health insurer. So it's important that when any of this goes on, that there's a thorough assessment and evaluation of the hospital to make sure that that reimbursement isn't going to cause that hospital financial problems. A reduction ordered by Green Mountain Care Board cannot result in a decrease to a hospital or hospital network's projected cash on hand to below 125 days. And that's important. There are three or four different ways that we measure hospital financial health in this process. So it could be operating margin, it could be days of cash on hand, or it could be an inclusion of assets that are owned by the hospital. So all of those things can be considered. Days of cash on hand is the one, as we took testimony both from the Green Mountain Care Board and from experts in the field, that this seemed like the most appropriate, and the board has done a good job of identifying a specific number of days for measuring how to assess this and to maintain hospital sustainability while preventing Blue Cross and Blue Shield from becoming insolvent. Section 2 of the bill is regards with hospital budget review. So this section directs the Green Mountain Care Board in setting hospital budgets to account for any significant deviation in a hospital's revenue during the prior fiscal year in excess of the budget approved by the Green Mountain Care Board. So the key here is it has to be a significant deviation from the budget that the board sets in the first place. Well, it's not every year, it's not every hospital, and it's not every deviation, but it's a significant deviation, and that it could be analyzed by the board. And so this section allows the Green Mountain Care Board to adjust a hospital's commercial insurance reimbursement rates at any time during the year to ensure that a hospital stays within its approved budget. It allows the board, Green Mountain Care Board, this is the key here for this section, upon finding that a hospital made a material misrepresentation in information or documents it provided to the board, or that the hospital is materially non-compliant with its approved budget, to appoint an independent observer for the hospital. So I think we're all familiar with the work that has gone on with the University of Vermont Medical Center and Health Network, and that this reflects a way to avoid the months-long negotiation that just took place, that this will now be in statute, and it's forewarned, forearmed for hospitals to know that when they report information and are inappropriately, wrong information, materially non-compliant with the hospital budgets, that the board can take action. And the action is to appoint an observer, that in the case of University of Vermont, the observer has been appointed. And the observer may monitor the hospital's operations, obtain information from the hospital, and report findings and recommendations to the Green Mountain Care Board. The observer has the right to receive copies of everything related to the board's hospital budget review and the hospital must provide any information that the observer requests. The observer shall share information from the hospital with the board and the Office of the Healthcare Advocate, but will not otherwise disclose any confidential information. Green Mountain Care Board may order a hospital to pay for all or a portion of the cost of the observer. There is underlying opportunity, I should say, that to allow for any hospital to appeal under the current statute, any order. So Section 3 is the repeal of the independent observer on January 1st, 2030. And finally, Section 4, the effective date for the passage of this bill. Mr. President, so we're solving two problems within the bill. We're putting in place an opportunity for the Green Mountain Care Board to become involved in maintaining solvency for our only domestic insurer in Section 1. And in Section 2, we're putting in place a process when malfeasance in budget reporting takes place and allows for the board to intervene and allow for an observer to look at the whole budget within a hospital. This is something that we hope will never have to happen again. We know that, we've been working for years on maintaining financial sustainability of our hospitals. It's absolutely critical. If we don't have hospitals, you know the result. If we don't have an insurance company, you know the result. We don't get the care that we need. If the costs to our hospitals escalate and our insurance companies can't cover those costs through reimbursement, that they lose their reserves, we lose our hospitals, we lose our coverage. So both of these things are important. We know that they've been important for our largest hospital in the state. It's been obvious, right? It's been in the news. We've talked about it. But it's important for any hospital to be aware of the situations that can result in action by the board. So we're trying to bring folks together with this bill in an emergency situation. So I will end there with my report, but I will say that we heard from a long list of folks, Ledge Council, a reporter of the bill from the House, Alyssa Black, Representative Black, Susan Barrett, the Executive Director of the Green Mountain Care Board, Emily Brown, Deputy Commissioner of Department of Financial Regulation, Michael Del Trecco, President and CEO of the Vermont Hospital and Health Systems, Mike Fisher, Chief Healthcare Advocate, Owen Foster, Chair of the Green Mountain Care Board, Judy Fox, Chief Executive Officer of Rutland Regional Medical Center, Don George, President and CEO of Blue Cross and Blue Shield of Vermont, Devin Green, Vice President of Government Operations of Vermont Association of Hospitals and Health Systems, Nancy Kane, Professor of Health Policy and Management of the Harvard School of Public Health, Diane Lamphere from the Green Mountain Care Board, Stephen Leffler, President and Chief Operating Officer of the UVM Medical Center, Sam Peisch from the Health Policy Analyst of Vermont Legal Aid, Sarah Teachout, Director of Public Media Relations for Blue Cross and Blue Shield, and Kai Sampson, Commissioner of Department of Financial Regulation. I will say that when these folks came in, they were very open, they were clear. We heard from Don George of Blue Cross and Blue Shield, the commitment that Blue Cross and Blue Shield has made to the state and would like to continue to make to the state and to folks who are covered by commercial insurance. When we heard from Stephen Leffler of UVM, he was apologetic for what had happened. I think we should know that. Well taken, but it can't happen in the future. It can't happen to any hospital. We have to protect our hospitals as much as they need to protect us. So, Mr. President, with that, I will say the vote in committee was 320, and we ask for your support of this bill. It couldn't be more important to us as an emergency response to the crises that we see in our communities, first on the insolvency of Blue Cross and Blue Shield, and secondly, on any misinformation when hospitals present their budgets. Thank you, Mr. President.
The question is, shall the Senate propose to the House to amend the bill as recommended by the Committee on Health and Welfare? Are you ready for the question? Senator from Rutland.
May I interrogate the reporter of the
The
bill?
reporter is interrogated.
I thank the committee for their hard work on this, but I was wondering, was there any consideration given to a sunset on this bill?
Well, there is a sunset on the second part with the independent observer on section 2. There's no sunset on the solvency section. So right now we're at a stage, Mr. President, where Blue Cross and Blue Shield, we hope, will begin to emerge from insolvency. In fact, some of the recent fiscal information that we've heard from Blue Cross and Blue Shield suggests that they are moving in the right direction. So this may not become a needed process for them. So we're working hard to make sure that it goes forward. But there's no sunset on this.
I thank the reporter of the bill. Thank you, sir. Mr. President.
Are you ready for the question? Senator from Rutland.
Thank you, Mr. President. I'd also like to interrogate the report.
The reporter is interrogated.
Thank you, Mr. President. I was happy to hear that Judy Fox from the Rutland Regional Medical Center was one of the witnesses, and wonder whether the reporter could characterize her support or lack thereof, maybe some concerns regarding this bill.
So thank you, Mr. President. As I recall, the testimony that we heard from the Rutland Regional Medical Hospital was about how to put some assurance in the bill that all the financial pieces of hospitals would be evaluated when consideration was given for determining reimbursement related to the insolvency part of the bill, and then also consideration for hospitals, for example, on their bonding or other, so that when insurance companies were looked at, we were also take in consideration of what was going on with hospitals before decisions were made. We did include that in the bill. There's also the concern about having the observer. I do not remember specifically comments at that point. I have had other conversations with CEO Fox, and I understand that there are concerns about potential use of this. There will always be concerns about potential use of regulatory mechanisms. Thank you, Mr. President.
I thank the senator. Thank you, Mr. President.
Senator from Franklin.
Thank you, Mr. President. May I inquire of the reporter of the
The
bill?
reporter is interrogated.
Thank you, Mr. President. In reading the bill and listening to the comments of the reporter, did the committee come to a conclusion that there was a high likelihood that there has been misrepresentation that has been a factor in deciding to bring this bill and to include certain portions of it, particularly that portion that relates to findings of hospitals potentially making material misrepresentation of information and documents? Has that occurred?
Yes, Mr. President, that is exactly what I was, that was mentioned previously regarding the University of Vermont Medical Center and Health Network, where there was material misrepresentation that then resulted in an order from the board for that organization to provide some funding relief for specific organizations. So yes, there was, and that did trigger the need for the independent observer section of the bill.
Mr. President, was there any probing to determine how the misrepresentation occurred, whether or not it was deliberate, and were there any consequences for the individuals who did this?
So, Mr. President, that actually goes beyond the scope of this bill. That is part of the work that the board did in reaching its order. to have the hospital and hospital network pay certain entities a specified amount of money, and to putting in place the independent observer that is currently in process.
Thank you, Mr. President. But in the case of misrepresentation, if misrepresentation is deliberate, that's typically considered fraud, a criminal offense that ought to be investigated. Is anyone investigating this from the judicial or criminal standpoint?
Mr. President, as I said earlier, that is the role of the Green Mountain Care Board. It is not something that your Committee on Health and Welfare got involved with. The board has taken that up, and if they go forward with any criminal action, that it would, if they find that, I do not know that they have found that.
Do you know, does the reporter know, for example, as to whether or not the Green Mountain Care Board has consulted with any law enforcement authorities?
Mr. President, I would suggest, Mr. President, that that's a question that could be asked of the Green Mountain Care Board.
In other words, Mr. President, the committee did not even inquire about that?
Mr. President, the committee looked at the bill and legislation before us. We heard from the board, and the board is a regulator. We are legislators.
I see. Thank you, Mr. President.
Are you ready for the question? The question is, shall the Senate propose to the House to amend the bill as recommended by the Committee on Health and Welfare? Are you ready for the question? If so, all in favor say aye. Aye. All opposed, nay. No. The ayes appear to have it. The ayes do have it. And you've proposed to the House to amend the bill as proposed by the Committee on Health and Welfare. The question now is, shall the bill be read a third time? Are you ready for the question? Senator from Chittenden.
Thank you, Mr. President. As everyone in the chamber knows, we have multiple emergencies all the time, and our committees function on a simultaneous basis. One thing I want to point out is that we have all had our eye very much on the Education and Finance Committees. Committee on Health and Welfare and its chair have been dealing with, by some estimations, a larger crisis, and that is an insolvency in our insurers, insolvency potentially in our hospitals. I just want to express my deep gratitude to the senior senator from Chittenden Southeast for her work. If you look at the bill, it is an extraordinary bill. It is reaching into a situation where we're near collapse and holding those pieces together. And I credit the committee and its chair for that extraordinary work. Thank you, Mr. President.
Are you ready for the question? If so, all in favor say aye. Aye. All opposed, nay. Nay. The ayes appear to have it. The ayes do have it, and you've ordered third reading of H 482. We have on the calendar for action H 222, which was passed by the House February 14th, 2025. It was referred to the Committee on Judiciary, which reports it has considered the bill and recommends that the Senate propose to the House that the bill be amended as it appears starting on page 1665 of today's calendar, and that with such proposal of amendment, it ought to pass. Listen to the second reading of the bill.
H 222, an act relating to civil orders of protection.
I recognize the senator from Chittenden Central District, Senator Vihovsky, for the report of the Committee on Judiciary.
Thank you, Mr. President. Your Senate Committee on Judiciary made a small change that I will cover as I go through the bill as it came to us from the House. What this bill does is update some of our stalking statutes. Our stalking statutes are a little bit strange, and so in 2006, the legislature established a process that a person who is alleged to have been subject to stalking or sexual assault can obtain a civil order of protection, because they're not eligible to obtain a domestic violence order of protection because the alleged perpetrator is not a family or household member. You can only get a domestic violence order if the person who is stalking you or has sexually assaulted you is a household member or family member. And so the 2006 update allowed for someone who was being stalked or who had been sexually assaulted by someone outside their family or household to obtain a civil order of protection, which is quite important. Stalking is terrifying and is an act of violence, and we want to make sure that we are protecting anyone who is experiencing that. And so that was done in 2006. What we're doing 21 years later is recognizing that technology has added to the ways in which one might stalk someone. And so our current definition of stalking means to engage in the purposeful course of conduct that is directed at a specific person, and that the person engaging in that conduct knows or should know would cause a reasonable person to fear for that person's safety or the safety of a family member, or to suffer substantial emotional distress as evidenced by a fear of unlawful sexual conduct, unlawful restraint, bodily injury, or death, or would cause them to significantly modify their actions or routine, which might include moving from their residence, changing their established daily route to and from work, creating a serious disruption in their life, changing the person's employment or work schedule, or losing their job or time from work because of the behavior that someone is engaging in. What the amendment does is it adds the use of any electronic, digital, or precise geolocation device. This might be an AirTag or an app on someone's phone that is meant to track their behavior and movement, to surveil them and to know where they're going or what they're doing or who they're engaging with. They would need to do this continuously for 12 hours or more, or on 2 or more occasions over a period of time, however short those occasions are. So it has to be a pattern of behavior in order to qualify as stalking. So that is the update to the definition of stalking that is in this bill. The other thing that this bill does is it updates the options for relief that a person obtaining one of these civil orders might be able to get. It particularly around vehicle use or vehicle possession. So it adds language in subdivision C2I to permit the court to award temporary possession of a vehicle to the plaintiff, provided that the plaintiff is the owner or joint owner of the vehicle, is the primary payer on the vehicle loan, has primary possession of the vehicle or control of the vehicle, or has been restricted from using the vehicle by the defendant. It also, so in section, oh wait, hold on. I missed a portion. So it also adds oh no, hold on, sorry, I lost myself. And then in subdivision C2J, the amendment permits the court to require the defendant to complete a domestic violence accountability program approved by the Council on Domestic Violence. These programs are in existence and can be required in a final relief from abuse order, but they can't be required at this stage in the process. And so what this was meant to do was to allow someone, or to allow a judge to respond with a softer touch earlier on. A lot of times people don't necessarily want someone to face criminal charges, don't necessarily want, someone to go through the whole process. They just want someone to stop doing what they're doing. And these domestic violence prevention programs can be a tool in our toolbox to get someone to learn more about the impacts of their behavior and to stop doing what they're doing. This was a section that the Network Against Domestic and Sexual Violence supported. So this, like I said, would allow in this civil protection phase of domestic violence and sexual violence prevention for these domestic violence accountability programs to be a requirement for the defendant. However, unlike the other potential requirements, this can't be considered a criminal charge if they don't complete the program. It could be considered a civil contempt charge, but not a criminal charge. This is where we, the Senate Judiciary Committee, made a small change, and you'll see it in your calendar. We inserted the language that this civil contempt charge would be pursuant to Rule 16 of the Vermont Rules for Family Proceedings, and that was at the request of, I believe, the Attorney General's office, to make it very clear what the process would be to obtain this civil contempt charge. A court can consider the defendant's failure to successfully complete that program when determining whether to extend an order. Usually those orders are valid for 1 year, but they can be extended. So the court can still consider whether or not the defendant completed this program. It just wouldn't result in an additional criminal charge. Most of the other requirements in these orders of protection are specifically things the defendant cannot do in order to provide relief to the person who's got the charge. This is something the defendant needs to do in order to hopefully change their behavior. So your members of your Senate Judiciary Committee and some members that testified felt like this was significantly different than the other orders in the civil protection order. Section 3 pertains to temporary emergency orders of protection. These orders are only in effect for 10 days, upon which time a hearing is held to determine whether to issue a final order pursuant to Section 3 of the bill. The amendment in Section 3 provides that the court the ability to award temporary possession of the vehicles, as I explained earlier. This section, Section 4, requires the commission, the Domestic Violence Fatality Review Commission, which we talked about a couple weeks ago, to report on its biennial findings and recommendations on the number of defendants that were ordered to complete the Domestic Violence Accountability Program. So this is a reporting back on this change and whether or not it is being used and it is working. This is also a check-in for us to come back to see if the civil contempt versus a criminal charge is the right spot to be. It's a bit of a softer touch, but it's really meant to encourage the use of this program. The effective date of this bill is July 1st, 2025. We heard from Representative Arsenault, who was the sponsor of the bill in the House, Michelle Childs, Legislative Counsel, Charlie Glisserman from the Network Against Domestic and Sexual Violence, Carolyn Hansen, who's the Assistant Attorney General and suggested your Senate's amendment to this bill, Anthony Jackson Miller, who is an equity analyst at the Office of Racial Equity, Angela Lasso Jimenez, who is the policy and research analyst at the Office of Racial Equity, Kim McManus, who is the legislative attorney with the Department of State's Attorneys and Sheriffs. We heard from Eitan, I'm going to get the Nasreddin Longo, who is the chair of the Racial Disparities and Criminal and Juvenile Justice Systems Advisory Panel, or the RDAP, and Thomas Zone, who's the chief superior judge. Your Committee on Judiciary voted 5-0-0 to provide this expansion in definition to be in line with the realities of technology in 2025 of what it means to stalk someone, and to put another tool in the toolbox for people seeking civil orders of relief. And we ask for the Senate's support.
The question is, shall the Senate propose to the House to amend the bill as recommended by the Committee on Judiciary? Are you ready for the question? If so, all in favor say aye. Aye. All opposed, nay. The ayes have it, and you've proposed the House to amend the bill as proposed by the Committee on Judiciary. The question now is, shall the bill be read a third time? Are you ready for the question? If so, all in favor say aye. Aye. All opposed, nay. The ayes have it, and you've ordered third reading of H-222. We now have third reading of H-1. Are there any amendments prior to third reading? Seeing none, listen to the third reading.
H1, an act relating to accepting and referring complaints by the State Ethics Commission.
The question is, shall the bill pass in concurrence with proposal of amendment? Are you ready for the question? If so, all in favor say aye. Aye. All opposed, nay.
No.
The ayes appear to have it. The ayes do have it, and you have passed in concurrence with proposal of amendment H1. H44, Are there any amendments prior to third reading? Seeing none, listen to the third reading.
H44, an act relating to miscellaneous amendments to the laws governing impaired driving.
The question is, shall the bill pass in concurrence with proposal of amendment? Are you ready for the question? If so, all in favor say aye. Aye. All opposed, nay. The ayes have it, and we've passed in concurrence with proposal of amendment H44. We're passing over H50, which brings us to H505. Are there any amendments prior to third reading? Seeing none, listen to the third reading.
H505, an act relating to approval of amendments to the Charter of the Town of Barry.
The question is, shall the bill pass in concurrence? Are you ready for the question? If so, all in favor say aye. Aye. All opposed, nay. The ayes have it, and you have passed in concurrence H505. We have on the calendar for action H209, which was passed by the House February 12th of 2025. It was referred to the Committee on Education, which reports it has considered the bill and recommends that the Senate propose to the House that the bill be amended as it appears starting on page 1666 of today's calendar, and that with such proposal of amendment, the bill ought to pass. Listen to the second reading of the bill.
H209, an act relating to intranasal epinephrine in schools.
I recognize the senator from Addison District, Senator Heffernan, for the report of the Committee on Education.
Thank you, Mr. President. Fortunately, I left my notes down at my desk, so I'll have to wing this a little bit. This is the bill that we looked over, the epinephrine, sorry about miscorrect spelling, saying it, in schools. From what I understand, in the past years here in the Senate, they tried to get it passed, and then the wording was becoming an issue. And between the interested parties in the bill, they came to understanding between all of them for the language that's now in the bill that is highlighted on 11. This is going to change the amendment to, from 12 VSA 531 to amend as read, to read as in the definition. Hang on. Yeah, I got the wrong. I was looking at 222. Yeah.
If I might ask for a brief recess.
We'll take a brief recess.
Thank you. I'll go grab my notes.
Ready, Chrissy?
I love that.
Will Senate please come to order? Senator from Addison.
Thank you, Mr. President. My apologies to the Senate. Okay, I rise today to report Bill H-209, an act related to intranasal epinephrine in schools. This recommendation is a bill to be amended by striking out all after the enacting clause and inserting in its place the following. Section 1, 16 VSA 1388 is amended to read, stop supply emergency administration of epinephrine. What makes this bill particularly noteworthy is the collaboration among all the interested parties. The cooperative effort led to an agreement upon the language, which in turn made our job as lawmakers significantly easier. It's a model of how thoughtful engagement and sharing goals can result in a strong, effective legislation. So, there was corrections in the bill, as I was saying before. On line 12, we changed it from the added language, complete training required by the state board policy, and who has added language there, and then delegated by the school nurse was added, as well as other language in accordance with providing standing orders of protocol and pursuit. And then we struck out, and who has completed training required by the state board policy. We struck out auto inject and added in what the Food and Drug Administration approves as sorry, this word gets me. Epinephrine's delivery system containing doses. The rest were basically through the bill. We're just adding school nurses, the meaning of school nurses, and or associate nurses endorsed by the Agency of Education, pursuant of a licensing of educator and preparation of educational professionals. We added that. We struck auto inject and struck access on line 16 and add recognizing, as well as all throughout the bill struck auto inject. That pretty much completes what we did with the bill as far as just striking auto inject, added school nurse on line 7, and then struck out on page 14, January 2014, just included the verbiage thereafter. We had our witness list, and testimony came from Representative Leslie Goldman. She was the sponsor of the bill from H209. Caitlin Cortez, state school nurse consultant, Vermont Department of Health. Katie McGlynn, Legislative Counsel, Office of Legislation Counsel. Courtney O'Brien, Intern Director of Operations and Agency of Education. Jessica Scafano, Policy Director of Vermont Department of Health. And Elisa Stalberg, Family and Child Health Director of Vermont Department of Health. It was voted out of our committee 5-0-0, and we asked for the Senate report. And my apologies for such a poor report. It will not happen again.
The question is, shall the Senate propose to the House to amend the bill as recommended by the Committee on Education? Senator from Chittenden Central.
Thank you, Mr. President. May I inquire of the presenter of this?
The presenter of the bill is interrogated.
Thank you, Mr. President. Did the committee, so actually, does this change in striking out auto injector and adding in intranasal create a prohibition on schools administering epinephrine by auto-injector?
Thank you, Mr. President. No, what it did, we struck out auto-inject because there's now more than one way to administer it, either nasally or auto-inject. So it does not prohibit any of that. It actually
Okay.
helps.
Wonderful. And who provides the epinephrine? Does the school cover this, or does someone bring it in?
Mr. President, from what I understand, the school provides it.
Thank you so much.
Thank you, Mr. President.
Sorry.
Senator from Windsor.
Thank you, Mr. President. May I inquire of the presenter of the bill?
Presenter of the bill is interrogated.
I thank the presenter for the brief remarks. If I could just say in layman term what I believe the bill is doing so I can get clarity. So right now, if I have an allergic reaction to peanuts, let's say as a child, there is an EpiPen that I have my parents have gotten a prescription for from their doctor that my nurse keeps in the school. And that pen is like the jab pen that we're all familiar with. There's also the nasal spray which you inhale. So this is now just allowing the nurse, the school nurse, to use that if I have an allergic reaction. Is that an accurate reflection of what the bill does?
Thank you, Mr. President. Yes, it also allows anyone trained to do it as well.
So if my teacher or assistant nurse was available, they could also provide the nasal spray.
If they are trained and as it says in the bill, authorized to do so.
Great. I thank the presenter of the bill, and that concludes my questions.
Thank you, Mr. President.
Are you ready for the question? The question is, shall the Senate propose to the House to amend the bill as recommended by the Committee on Education? Are you ready for the question? If so, all in favor say aye. Aye. All opposed, nay. The ayes have it, and you've proposed to the House to amend the bill as proposed by the Committee on Education. The question now is, shall the bill be read a third time? Are you ready for the question? If so, all in favor say aye. Aye. All opposed, nay. The ayes have it, and you've ordered third reading of H209. We now have S117, which was passed by the House with proposal of amendment. The question is, shall the Senate concur in the House proposal of amendment? Senator from Chittenden.
Thank you, Mr. President. So this bill has come back to us from the House, and it is 95% of what you've already seen. Where I will speak to, just because we are now I am between you and lunch, I will focus on where the changes are and just recall some of the bill contents that you've seen prior. Additionally, because our counterparts in the chamber have different committees of jurisdiction with more granularity than us in the Senate, they have added content to this bill from another bill that passed this body, S125. So 95% of this language is what you've seen before, but I'd say about half of it was in a different bill. So I will just call that out as I walk through some of the changes. One thing that our counterparts in the House did do is remove sections 1 through 4. That was a section that your Committee on Housing and Economic Development, Housing and General Affairs spent a great deal of time on. We did because it was giving a fast pass or a fast track for how VOSHA, Vermont Occupational Safety and Health Administration, could implement the federally mandated rules. And we wanted to make sure there were enough guardrails and that it was consistent with other mechanisms currently in state law to be able to avoid some of the more laborious and sometimes expensive in both time and necessary fees charged. There was more conversation on that sections that we had a lot of conversation on, and I understand that the House, in consultation with the support of the Vermont Department of Labor, suggests that we do not do that this year. We're going to have some more conversation, come back next year and maybe reconsider it. So they deleted sections 1 through 4. Additionally, in section 7, that was cleanup language from a bill that was brought to us, I believe, by the Windsor delegation, if I may, from S6. This just expands upon what the Windsor delegation put forward, which was cleanup language from some carryover rules passed in 1959 that is really circumvented or overridden by other minimum wage laws. So this just expands it. It had to do with the commissioner had the authority to lower the pay for those with disabilities, and that They've never used it, they don't use it, we don't need it in law. We just struck some additional language there that also no longer allows through this statute the commissioner to lower pay for learners and apprentices. That is still overseen in other statutes in the law. That's more consistent with current federal law and other regulations. So again, no big changes there. Section 8 was deleted as well. This too, with further conversation from in the counterparts in the House, as this process works so well. Conversation continues, people understand it. They did delete that section that originally came to us from the Vermont Department of Labor, but the Department of Labor, upon further consideration, did ask that to be withdrawn. Had to do with how layoffs would be notified depending on the size of the organization. I don't have all my notes on the details. Regardless, they would just like more time to consider it, maybe bring it back next year in an alternative form. Other than that, section 117 is intact. And then if you start in sections 21A, 21A is a new section, and all it is an expansion of section 21, which you all approved in S117. That section just changed the deadline for the UI modernizing IT system implementation deadline, pushes it out a year. That's pretty common, and this just synchronizes with some other statute language, also allowing for that same one-year extension. So that is just a couple other areas that the DOL noticed was still in statute regarding when rules took effect, and so this just, again, allows for that one-year extension, but everything I've heard so far is it's on track. It's going to be in place next year. Other than that, sections 22 through 24 were in S125. I did not report that bill. I think it's relatively innocuous. If that's the right term, probably not. Not controversial. So if you do have any probing questions on that before lunch, I might phone a friend to the reporter of the bill, my seatmate, if I don't know how to answer questions on 22 to 24, but they are relatively straightforward. There was a small change to section 25 in the language that we passed in S125. It just removed some language that we added. They found it to be ambiguous, is what I understand, secondhand, and hard to interpret, and that's fine. But what they did do is they removed that language having to do with when an employer is obligated to pay a fee if they don't make good in a timely manner when they owe workplace workers' compensation payments. So this clarifies more specifically that they have to establish a day, and if that day is not necessarily met, they do have to pay a fee. And that was the original language in S125. And now what they did add, which received positive feedback from the department, was in fact a report, because these fees that are paid, if an employer has to issue workers' compensation to an employee and doesn't meet these deadline fees, already in statute there was a fee. That fee would be paid by the employer to the employee. The state has no idea how often that's occurring because we're not part of that exchange. So what this report does is requires employers to generate a report when they issue, or to report when they issue this late fee and as to why. Because we want to get a better handle on how often this is occurring. On testimony we received in committee, it is unknown how often this is happening for just those reasons. So this will allow us to get a better understanding of when workers' compensation is not necessarily paid in a timely manner according to what we have in statutes. And that report will, the reporting from the employers to the state will then be another report, because we love reports. It will be a report to us about how many of those employers have paid these late fees, and that's what will come back to us in a future legislative session. The other changes have to do with the effective dates. Your Senate Economic Development, Housing and General Affairs Committee voted on 5-0 to support this proposal of amendment from the House, and we urge the Senate to concur. Thank you, Mr. President.
The question is, shall the Senate concur in the House proposal of amendment? Are you ready for the question? If so, all in favor say aye. Aye. All opposed, nay. The ayes have it, and the Senate has concurred in the House proposal of amendment on S117. Senator from Rutland.
Thank you, Mr. President. I move the rules be suspended and the 7 gubernatorial appointees who are listed in today's calendar, whose names are not underlined, be taken up together without debate or confirmation.
Senator from Rutland has moved that the rules be suspended and all gubernatorial appointees who appear in today's calendar, whose names are not underlined, be taken up together and without debate, and that they be confirmed by the Senate. Are you ready for the question? If so, all in favor say aye. Aye. All opposed, nay. Nay. The ayes appear to have it. ayes do have it, and the motion carries. Senator from,
Remembering where I'm from.
we're going to take a quick recess, Senator from Chittenden. Will the Senate please come to order? Senator from Chittenden. Senator from Chittenden.
Thank you, Mr. President. I have a point of information. The vote we just took, wasn't that on the motion to bring those up off the calendar, not to approve them?
Senator, the question is actually to be taken up together and without debate, and that they be confirmed by the Senate.
Okay, thank you.
Senator from Chittenden.
Thank you, Mr. President. At this time, I would move that the Senate suspend its rules in order to take up pending notice H91 and move it to the Appropriations Committee via Rule 31.
Senator from Chittenden has moved that the Senate suspend its rules in order to take up H91 for the purpose of referring it to the Appropriations Committee under Rule 31. Are you ready for the question? If so, all in favor, say aye. Aye. All opposed, nay. The ayes have it, and the motion carries. That completes the orders of the day. Are there any announcements? Senator from Chittenden.
Mr. President, I have two announcements, by the way, if you please. Earlier in the session, the Senate Finance Committee heard testimony from the Executive Director of the Vermont Community Broadband Board, and we asked to be kept informed of the federal funding landscape. Last Friday, the Executive Director shared that the Trump administration shared with the Vermont Community Broadband Board that their digital equity grant was being canceled. This abrupt cancellation will result in a loss of $5.3 million plus another $5 million over the course of the next few years, resulting in a total loss of $10 million in grants. Trump decided the digital equity program was, quote, unconstitutional, and grants issued pursuant to it were created with and administered using impermissible and unconstitutional racial preferences. The Digital Equity Act targeted rural, aging, and low-income Vermonters, veterans, people with disabilities, those with language barriers, and members of racial and ethnic minorities. And over 95% of Vermonters fall into one of those populations. The funding was meant to allow Vermonters to participate in the economy and engage in education, telehealth, remote work, and civil engagement through fiber optic infrastructure. I know we've asked to journalize many remarks this session, but it's important that the future generations look back and see that there were some in the Vermont Senate who shined a light on the threats to our democracy and the erosion of the principles of our Constitution. Thank you, Mr. President. I have a second announcement that's a little more happy and lighthearted, which is that the Senate, the State House has a group called the Bloom Crew, and we are enthusiastic gardeners. We will be working on a garden today at the west side of the building, right outside the door, and everybody is welcome to join us. That's at 2 o'clock. We will be planting flowers. Thank you, Mr. President.
Are there further announcements? Senator from Addison.
Thank you, Mr. President. I really appreciate the announcement of the senator from Chittenden. There are 3 members of the current Finance Committee, myself, the senior senator from Washington and the senior senator from Franklin, who worked on the broadband bill in 2021 that brought hundreds of millions of dollars into the state to expand our broadband access. And part of that plan was to include digital equity in the state of Vermont so that all Vermonters could have access to broadband. And that is now being sincerely undermined by the federal administration. And so with that, Mr. President, I ask that the remarks of the senator from Chittenden be journalized. Thank you.
The senator from Addison has moved that the senator from Chittenden Central's remarks be journalized. Are you ready for the question? If so, all in favor, say aye.
Aye.
All opposed, nay. The ayes have it, and you have moved to journalize the remarks of the senator from Chittenden. Are there further announcements? Senator from Chittenden.
Thank you, Mr. President. At this time, I would move that the Senate stand in adjournment until 10 a.m. Tuesday, May 20th. And a reminder to senators that we will be moving next week to a 10 a.m. start date uniformly across the week to allow us to move into conference committee mode. And with that, Mr. President, I will make that motion pending further.
Senator from Washington.
Thank you, Mr. President. Senate Finance will meet at 1:15.
Senator from Washington.
Thank you, Mr. President. Senate Appropriations will meet at 1:20.
Senator from Rutland.
Thank you, Mr. President. Government operations will meet at 2:15.
Senator from Bennington.
President, the Education Committee will meet at 1:20.
Senator from Wyndham.
Thank you, Mr. President. Senate institutions will go on a field trip to Windsor, arriving somewhere around between 2 and 2:30.
Are there further announcements? Seeing none, the chair has an announcement, and that is Senator White, you were busted again today on your phone. That is a violation of Senate rules, and I would request that you begin to leave your phone outside of the chamber if you cannot stay off of it. The senator from Chittenden has moved that the Senate stand in adjournment until 10 a.m. Tuesday, May 20th of 2025. Are you ready for the question? If so, all in favor, say aye. Aye. All opposed, nay. The ayes have it, and we'll stand in adjournment until 10 a.m. Tuesday, May 20th, 2025.